Case number 113253, State of Kansas v. Cortez Brown.
Morning. May it please the court, counsel. My name is Corey Collar, representing Cortez Brown. I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Mr. Brown was charged with felony murder, or in the alternative, second-degree intentional murder, aggravated assault, and aggravated burglary. Prior to trial, he filed a motion to have new counsel appointed, and that pro se motion, that motion was subsequently withdrawn by his counsel, and then he was convicted of the charges. At sentencing, he brought that claim forth again, and the sentencing judge just told him it disregarded his complaints. This court subsequently remanded it for an evidentiary hearing on that motion. The district court held the hearing, took evidence from Mr. Brown and trial counsel, and determined that there was no breakdown, no complete breakdown in communication, and denied the motion.
Excuse me, counsel, before you proceed, again, for our audience who's watching this over the internet, could you give us a short recitation? In other words, what was at stake for your client given the ruling of the trial court?
Well, he was charged with felony murder. Mr. Brown's cousin's girlfriend was with a man at his house, and she came to believe that he was one of the men who had gang raped her a couple years before. And so she went back and told Mr. Brown's cousin, who then got Mr. Brown, and they went over to the man. They were going to rough him up, I think beat him up. I don't think there was any, I think the testimony was they weren't going there to kill him, but nonetheless, the victim was ended up shot and killed. So Mr. Brown was charged with felony murder. And Mr. Brown alleged in his motion that there was a breakdown in communication with his counsel. This counsel wasn't listening to his concerns, and he wasn't, Mr. Brown wanted the trial to go quickly, and there had been continuances and these sort of problems. And then there was sort of a disagreement then about what happened. The trial counsel went to see him about a week later, and according to trial counsel, we talked about it, and he got on board. The trial counsel admitted he hadn't been putting the time into the case that he probably should have, but the waters had parted. Mr. Brown was now up, and he had the full attention. And Mr. Brown remembers it differently, that he came, the attorney came, talked to him, pleaded him not to have him withdraw from the case, but that Mr. Brown said, I don't want to talk about this, we'll talk about it for the judge. And then counsel withdrew the motion, and there was no hearing held.
Yeah, and one of the questions that came up before was that the defendant wasn't present or wasn't asked by the district court whether he wanted his motion withdrawn, okay? But, so now you've got a hearing, and I guess I don't understand why, if the judge believes the lawyer's testimony about meeting with the client, and in fact there's a letter, that January 24th letter, that seems to back up the lawyer, that says they had a meeting, they all agreed, they were done, and the motion was withdrawn, that the defendant had a stay in it. And it seems to me the dispute is over at that point. So I'm having difficulty understanding why you aren't happy at this point.
And that's the problem, I think, is, and the problem inherent in this case, and I'll admit, the standard view here is abuse of discretion, and that's a tall mountain to climb, and the judge was present to hear both sides of it, and I understand that. The problem is that I think the nature of the allegation is that Mr. Brown says that the attorney wasn't listening to my complaints. He wasn't listening to what I had to say. And so when the attorney says, we talked this out and everything worked out fine, and the defendant says, no, I was still dissatisfied. That I understand, if you believe it from the attorney's perspective, everything was fine. But from Mr. Brown's perspective, there was still this breakdown in communication. If you have a breakdown in communication, disagreements or differences in opinions of what happened are, I'm not sure they resolve it. And I think we can look to other things that happened, other issues that came up.
But I think Justice Biles' question maybe goes to a procedural issue that I'm kind of confused about in this case. Because are we focused solely on that pretrial motion? And if so, as Justice Biles has indicated, once that pretrial motion, the court has said, no, at that point in time, I agree with the evidence submitted by the defense counsel and would say that the defendant agreed to withdraw the motion. Are we done? Or are we looking at something else? I mean, and the something else that I suggest might be there are Mr. Brown's statements at sentencing where the trial court just basically told him, I don't want to hear from you.
Right. I think, as I understood it, the remand was based upon both the motion and the comments at sentencing. And the remand was to determine whether or not there was a complete breakdown in communication. And I think it's fair to say at the time when there would have been a hearing. The judge would have held a hearing at that point. And I suppose maybe also at sentencing, but certainly at that point. And so I don't think we're limited to the four corners, to the allegations, the four corners of the pro se motion. If the defendant at the hearing, I think he did, raises concerns about the breakdown in communication and presents evidence that of a breakdown in communication that would allow a reasonable judge to say, okay, there was a breakdown in communication. Even if he didn't put a particular allegation in the motion, there's evidence now before me of a breakdown in communication. I think that's something that the court can and should consider. Does that answer?
When you say at the hearing, you're referring to the remand hearing?
The evidentiary, that's correct, of the evidence about what happened during that time.
So
Did it have to be prior to the motion or around the time? I think maybe I'm misunderstanding the question, Justice Lukert, but I thought you were saying should evidence of what occurred after also be considered since the procedural posture of this case is that it went back on remand from an appeal.
Right. I think that was there a complete breakdown in communication and the time would be at the time of the hearing. And I think you can look at evidence of the breakdown in communication, evidence of things that happened subsequent to that will give you insight into the relationship before. In other words, if there's a complete breakdown in communication prior to the filing of the motion, presumably that breakdown would continue. For example, in his failure to testify, he said that I wanted to testify, I didn't, and he told me to testify, so I just went along with that.
Wasn't there a colloquy between the trial judge and Mr. Brown about testifying?
There was, and
can't we consider the fact of what he didn't say? After that motion was withdrawn, he proceeded to trial. He proceeded to tell the judge he didn't want to testify, and we heard nothing about I've got complaints until after the fact where he's already been convicted.
Sure, and I think you can consider that. I think you would also consider, I think it's sort of the reasonable position of Mr. Brown that once his motion was withdrawn, he filed the motion, I want a new attorney, and it was withdrawn. He had two choices. He could proceed with this attorney, or he could represent himself. That's what he viewed the choices are, because his request for a new counsel had been not only denied, but ignored. And so he could either stand up and say, I'm going it alone, or he could go with this counsel. So certainly, I mean, he made those comments, and I think you need to take that into account. But also, I think it's a reasonable position for a layperson to take.
Let's concentrate on the remand hearing.
Yes.
Can you be precise in how you believe that judge abused discretion?
Sure. I think that the judge, in focusing, in determining whether or not there was a breakdown in communication, seemed to apply more of an effective assistance standard analysis than sort of the communication. For example, the photo array. There's a photo array issue, and the defendant wanted to see a copy of the photo array. Now, the photo array was a complete non-issue because the witnesses who saw the photo array did not identify Mr. Brown. And in fact, the co-defendant identified Mr. Brown, and there was Mr. Brown's DNA. So it was of no moment in the trial. But it was important to Mr. Brown, and Mr. Brown apparently did not understand this. And so I think that was evidence of the breakdown in communication. The district court judge, however, talked about that the photo array was a strategic issue, that it was strategy. And I understand that the decision not to pursue or not to attack the photo array, that was a strategic issue, but that wasn't the issue before the district court judge. The issue was whether or not, talking about the communication between Mr. Brown and trial counsel, and the disconnect between what Mr. Brown understood and what what the trial counsel believed to be true had nothing to do with strategy. It had to do with their lack of communication.
So the particular part of our standard of review for abuse of discretion that you're focusing on is that the judge at the remand hearing applied the wrong legal standard?
Yes, I think that would in that particular yes, in that he did not. I guess it would almost be a factual analysis, though. I guess because the legal abuse of discretion, but it was I think whether or not he looked at whether or not he held that the trial counsel was strategy, and I think that is whether or not that bore on the communication. I think that may be a factual question of whether the strategy bore on their communication more so than that he was looking at whether the trial counsel was ineffective. I mean, I don't think he was doing that. I think he was saying there was no communication error because it was strategy, which isn't the point.
But wasn't that consistent with our remand order, which was really a two-part thing? We said the district court shall determine whether Brown has established justifiable dissatisfaction with his counsel. And I understand that's where you're focusing and saying, no, the trial court didn't look at the full picture. But then the second part of what we ordered is whether that conflict adversely affected the adequacy of the attorney's representation. And can't the trial judge's orders really be said to fall within that second prong? And that there may have been some lack of communication, but it didn't adversely affect representation?
I think yes. I think if you look at those particular things, then you could say that the photo array, and also there was a disagreement, a misunderstanding about the discovery order, and that those both were miscommunications, but that those particular miscommunications did not affect his representation. But I think it's not a question of whether the evidence which supports the breakdown in communication affected representation. The question is, was there a breakdown in communication? So you have these two things, the photo array and the discovery, which are evidence of a breakdown in communication. And then, does the breakdown in communication, did that affect the representation? And the part of the communication that affected the representation was specifically his decision not to represent himself, which, as I said, was addressed. And there was communication there, but there wasn't. Mr. Brown didn't feel as though he could adequately discuss with his attorney his concerns about representing because of the breakdown in communication, which was evidenced by the photo array and the discovery. Does that answer your question?
Well, I'm not sure I understand. Let's, if I can just cut straight to what I think is the point. Just assume that there was a breakdown of communication, and maybe the district court should have explicitly found that. We just assume that. Where's the adverse impact? Given the district court's findings on the adequacy of the representation on those specific issues that you cited, where is the adverse impact of my assumed breakdown of
Right, sure,
communication?
absolutely. Well, I think I would rely heavily on his decision not to testify. I think at the evidentiary hearing, that was what they stated most clearly, that the relationship was such that he felt that he had to just sit down, shut up, and do what his attorney told him to. And obviously he has the right and the sole right to make the decision to whether or not to testify. And the attorney advised him, you shouldn't testify, it'd be bad for you. And he wanted to testify, but because of this breakdown in communication, he felt that he had to accede to the wishes of counsel. And that therefore denied him the right to testify, which that was what affected the representation.
So your argument is essentially that the breakdown of communication denied your client the right to testify.
Yeah.
Is that the standard? I mean, to me, that's different than whether or not the breakdown in communication created what amounts to an ineffective assistance of counsel claim.
Well, I think it can be a lot. I think a lot of things can fit under that umbrella.
Because the counsel could have been very effective and properly advising his client not to testify, right? And the defendant, your client, could still feel aggrieved by that.
Right, and I guess it depends on whether the decision to testify, the fact that whether that's a good decision or a bad decision is still the defendant's decision. And an adequate defense where the defendant is denied the choice, or a defense where he is denied the choice, even if it's a bad choice, which frequently is, then that is, he is not getting an adequate defense, or he's not able to participate in that defense because of the breakdown.
How was he denied the opportunity when the judge specifically spoke to him and told him he has the right to testify? Is it your choice not to testify? I mean, I don't understand how he couldn't say, yeah, I want to testify to the judge, right? I mean, in a court of law, I'm not understanding how the advice that this is really silly if you testify, but you can do it, and then the judge says you want to testify, and he goes, no. Where's the denial?
Well, I believe the denial, again, it goes back to the communication between the two, that he, because his motion was withdrawn, and because of this, the breakdown in communication isn't, I believe, an advice breakdown where the attorney wasn't telling him anything. It was a breakdown to where he was unable to present it to defense counsel, and that he felt he had to go along with the decisions made by defense counsel. And defense counsel told him, you shouldn't testify. And so he went along with that because he wasn't able to communicate well with defense counsel.
But don't we
So
have a
what-
factual finding from the trial, the remand, after the remand hearing, of the judge just saying, I don't think that was what happened here? He made the decision not to testify.
Yes.
And that pretty much ends it, doesn't it?
Oh, well, it's difficult. They don't have an answer for that. Sorry.
Do we have any more questions of counsel? I see you've reserved 3 minutes for rebuttal.
Thank you.
Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I think that this court, in its questions of opposing counsel, has really hit on the theme that I wanted to stress in the oral argument today, which is that this case was remanded so that the defendant could have his day in court on this motion. The mistake that was made the first time around was that the court didn't personally bring the defendant in and determine whether it was his own decision to want to withdraw that motion. And so that's what it was sent back for. He had a full hearing in which he was able to testify and explain what this conflict or what this breakdown in communication was all about. The court at that hearing heard from the defendant, from the defense attorney, and from the prosecutor, admitted several, I think 4 exhibits into evidence, and then made some very detailed findings. Our position, quite simply, is that the court's findings are supported. The defendant, I think when you boil it down, like a lot of criminal defendants, probably like every criminal defendant, would have liked it if Mr. Mank were available to him 24 hours a day throughout the time that this entire case was pending. We all know that that's not feasible or required. I think Mank's testimony was very clear in indicating that he did spend a significant amount of time talking to the defendant in person. He wrote him numerous letters. They communicated about things. Counsel's correct. I think there's probably support in the record for the fact that maybe the defendant didn't fully understand why the photo array was a non-starter, but that was something that the testimony at the evidentiary hearing shows was discussed between the two.
There's some limit. It's the, I can explain it to you, but I can't understand it for you situation.
Yes, exactly. I think the fact that the defendant doesn't understand doesn't mean that there's not communication. Sometimes concepts are just not necessarily easy to grasp for a non-attorney in that situation, but that doesn't mean that Mr. Mank didn't do his part to communicate with his client. I think that when you look at the court's ruling in its entirety, and it's set out in great length in the brief, it came down to a credibility finding, and the court simply found Mr. Mank's testimony credible, that he did all these things that he testified to with respect to communicating with his client. And there was documentary evidence also showing that he sent these letters, that these decisions were made after consultation. Specifically, it showed that the defendant had told Mr. Mank that he wanted to withdraw the motion. I don't think that anything that happened at that evidentiary hearing would lead to a conclusion that the district court's ruling was one that no reasonable person would agree with here. The defendant had his opportunity. Unfortunately for him, the testimony from Mr. Mank was credible and refuted the allegation that there was not sufficient communication. It's obviously a high standard to show that there's a complete breakdown in communication, and the defendant falls far short of showing that he met that standard or that the district court abused its discretion in denying the motion. He's now had multiple opportunities to, I think the question that Justice Johnson asked is a good one, is that today the focus seems to be on that this somehow denied him his right to testify. As Your Honor pointed out, the judge himself went over that with the defendant at the time of trial, and of course the defendant did not indicate that he wanted to testify but was somehow restricted from doing so by Mr. Mank. So I think that just is in keeping with the general theme of this case, which is that the defendant many times has argued that he had certain complaints and that he wanted issues heard, but that he had multiple opportunities to bring these to the attention of the court and never did so. Since the time the initial brief was filed, he's now had one more opportunity, which was the full evidentiary hearing. And again, I think that the testimony and the documents that were admitted into evidence very much support the trial court's ruling, and I don't think there would be any way to reverse that ruling without just expressly overturning the district court's credibility findings. So for those reasons, it's our position that the district court did exactly what it was called upon to do in the remand order. Its decision was one that a reasonable person could agree with, and therefore there has been no abuse of discretion. If there are no further questions, we would respectfully request that the district court's decision be affirmed.
Any questions? Thank you, counsel.
Thank you. One of the advantages of rebuttal is I get time to think and look at things. And it appears from a quick review, although it's only a few pages, so hopefully that the district court here did not specifically address the failure to testify issue. He didn't make any findings on that. Well, I think, which makes sense because the judge found that there was no breakdown in communication. Therefore, he did not need to move to were there any consequences from that breakdown. So it doesn't appear to me that the judge made any findings about whether the defendant, about their conversations about his right to testify, and whether he just acceded to the counsel's wishes on the right to testify, which I think was the heart of your question.
Well, there may not have been specific findings about that, but why do not the general findings that there was no basis for the dissatisfaction with counsel after the judge had heard evidence about the question of how it might have affected the right to testify, get us to the same point?
Well, because I think the judge, looking at his ruling, focused on the photo array and the discovery and the pre-motion, the complaints about the pre-motion communication, and found that, as I said before, I think he looked at it wrong. So is this just strategy, and didn't really look at the communication. So I don't think that those translate to the communications about his right to testify.
Except the judge also said, I'm looking at it primarily as it existed at the time of the motion was withdrawn, maybe secondarily looking at it with hindsight.
Right, and I guess what
he implied he was looking at it more.
Yeah, I think that's his perspective. He put himself in the position as if there would have been a motion, as if he would have sat on the motion that was withdrawn. He would have sat in that hearing. And then he also looked at hindsight of how things happened during the trial as well. But I think his focus on whether or not there was a breakdown in communication was on the events that occurred prior to the motion being filed. I got you.
I think I understand your point.
Thank you.
Now,
Yes, I was just going to ask if we had any further questions. Please proceed.
yeah, I'm struggling a little bit with your right to testify and a breakdown in communication. My understanding is that he feels like he didn't get the right to testify because his counsel communicated to him that it was not in his best interest to testify. But then you're saying that this all was a justifiable dissatisfaction because there was a breakdown in communication. Why wasn't that communication? I'm telling you, my best advice is don't testify.
Right, and I think it's the difference between advice and communication. And advice is a one-way street, and certainly the attorney gave him advice, but the communication is a two-way street, and the attorney, in advising him that he shouldn't testify, did not listen to his concerns and what Mr. Brown was trying to communicate to the attorney. And certainly that Mr. Brown didn't feel like he could go against what was said because of the breakdown in communication. It would be that the attorney may believe that that's the right course, but unless he hears what Mr. Brown believes and listens to Mr. Brown's words about why he should testify, he can't make a reasonable advice.
Which gets us back on to that, if we can borrow a term from the civil side, that intervening cause of the judge saying, but this is your decision. It's not your attorney's decision, it's your decision. And he says, no, I don't want to testify.
Right, and I would go back to that his belief that at that point, he believed that if he went against, that he had to either abide by his attorney's wishes or proceed on his own. And he did not want to proceed on his own, as I understand his testimony. That at that point, if he would have said, I want to testify, at that point, he would have been proceeding on his own.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time